Lordship, there is a bit of an urge.
Sir,
Lordship,
you don't know anything. You have come to mention you do not know whether it is order 41
Lordship, it is
or
order.
what is what. Then
Lordship,
why you did
it
not
is
do?
order 41. It is order.
That's all. Yes, call her.
Lordship, this is my appeal. Lordship, I'm praying for short passover. Lordship, my senior is on his way. Lordship.
No, you do it. Group 7.
Lordship,
seven matter.
yes, Lordship, my senior would be joining virtually, Lordship.
Whatever. Which order you are assailing?
Lordship, will kindly come to my paper book, volume 2, Lordship. Lordship,
from the memo. Memo, what is the order dated?
Lordship, the impugned order is at page 378, Lordship.
Oh, date.
Lordship.
Give the date of the order.
15th of March, Lordship.
Say that.
15th of March, 2022, Lordship.
Let us see. There are 2 orders you have annexed with the memo.
Lordship,
that's why I'm asking.
Lordship, the final impugned order is 15th of March, 2022, yes, Lordship. Lordship,
just take your seat. Let us hurriedly go through this.
Lordship. Lordship, after The impugned order was passed, Lordship. There was another, this matter had been taken up by the Honorable Division Bench by an order dated 23rd of August 2022. Leave for filing supplemental grounds of appeal was also granted, Lordship. Lordship, my senior is on virtual.
Yes.
No, I am not
May I just indicate
Mr.
one thing, my
Mishra.
lord? Can number 5 is there. That is an application filed by my learned friend's client, my lord. Kindly see once only. Their only ground was, my lord, the money should be released without hearing the appeal because I have not filed the paper book. Now, in the affidavit in opposition, I have annexed an order of this honorable court, my lord.
My lord, I can
November
assure Mr. Roy.
Mr.
I
Roy, you are moving an stay application, I believe.
My stay application has not been recorded to be disposed of, but the order was, my lord, they should not proceed with the contempt application and the appeal will be heard. This is the order, my lord, pith and substance of the order that was passed by the earlier court.
Where is that order?
Lordship, page 404 of the paper book, Lordship.
এটা hearing matter কেন তুমি এটা দিয়েছো application এ?
Well, this is, and I am because they moved the contempt application also, my lord. Kindly see the
My
order.
lord, I can, my lord, cutting the matter short, my lord. The contempt application has been filed by us. Where are the judges?
This is this.
We understand. There is no stay of the operation of the order.
My lord.
My lord.
About it. There is already a clear-cut finding which has been made there by a single judge relating to the refund of a certain amount.
My lord.
Absolutely, my lord.
Now, if that being the position, in such scenario, I do not know whether any kind of an order that you should not proceed with the contempt can be passed. I am not aware of this kind of an order ever.
No, a coordinate bench.
Lord,
has-
moreover, my
No,
lord,
Malad,
your
may I-
lordship will
may I-
see.
in that case, Malad, may-
Now the question, we are not entering into the question. You have not been blessed with the order of stay of the refund.
Malad.
That is still there. The bench wanted the hearing of the matter. We are fixing this matter because it is otherwise ready.
Yes.
Today we are only for the applications. All applications and appeal we are fixing. Tell both of you when you are ready to do the matter.
My lord, I am ready right now, my lord. Any day convenient to your lordship, so your lordship kindly fixes the
I do
matter.
not want that others should wait for this matter. Tell us next week, any day, when both of you are
Any
are
day
here.
convenient to your lordship, my lord.
Malad,
Every-
second April, Malad, 2nd April is
Why is next week I am talking about, sir?
it's next week. Next week, Malad. Next week, Malad, 21st or 22nd.
21st? 21st, are you ready?
Malad.
Yes, my lord. Yes. Grateful.
Matter has wrongly
Sub-
listed.
Subject to leave, Lordship. Subject to leave.
Your senior has already
Lordship,
argued.
I will.
Then,
Malad.
Mr. Roy,
20
your
seconds.
junior is not really is happy with your submissions. So
Malad, I'm sorry, Malad.
Lordship will not take me amiss. Lordship, 22nd, I would not be there to
unless you
assist.
grant a leave to argue, then he will argue the matter.
I apologize. I apologize.
We sincerely apologize, Malad. This
I
happens,
apologize,
Malad.
Lord. I
Anxiety, Malad, kindly consider, Malad. Please do not get us to.
So both of you have agreed that on 21st, I am fixing the matter on 21st.
Malad, but if
Grateful.
my learned junior has got some, Malad, only prayer, Malad.
21st, has he a problem?
No, that's
That is what I was saying. 21st, I would not be there to assist my learned senior. 22nd,
No,
Lordship.
that's why I said amongst you, you talk to him. Why you are making submissions to us? Talk to him.
He's on virtual, Lordship. I cannot.
No, you can't. Whatever you're saying, he's listening.
Sir, 22nd.
22nd. Yes.
Yeah, he can hear it.
I apologize.
We apologize, not 22nd.
I apologize, sir.
22nd, Malad.
Yes.
22nd.
Yes,
Malad.
my lord. Agreeable.
This matter is listed under the heading application as the respondent in the instant appeal took out an application being CAN 5 of 2022 seeking the seeking the release of the amount forthwith. Our attention is drawn to the earlier orders passed in the instant appeal by the coordinate bench, wherefrom it appears that the coordinate bench intended to dispose of the matter finally and directed the parties to prepare paper book, which in fact has been filed. In such view of the matter, and on the consensus of the respective councils appearing for the parties, let this matter be listed on 22nd March 2024 for final disposal, along with all applications. Let the appeal follow, not matter. Let the appeal be listed along with all pending applications.
Deeply obliged, my lord.
Grateful. Grateful.
To be
Obliged.
taken up at the first sitting of the court.
Deeply obliged.
Lordship, I tender my unconditional apology, Lordship. I was not,
Lord, when your senior has submitted, you should tell him.
Lordship, virtually I am not all that accustomed, Lordship.
You are audible. Whatever he is arguing, you are audible.
Lordship, I apologize, Lordship.
Yes.
Unconditional.
Let's call the next matter. Is the first time appearing or second time?
It also appeared on last opening.
Anybody
I
appeared?
think I was also not represented. This is the first time I am represented.
Not today. Other side is not here. Yes. এটা কি ফার্স্ট টাইম না আগে থেকে অ্যাপিয়ার করছে? হ্যাঁ?
I am for the respondent. Same matter, identical issue.
Not today.
Lordship,
What is this application, madam?
Lordship,
Cat one
this is
and
an application for condonation of delay of
How much days delay?
50 days.
50 days.
Section 5, I am not opposing.
We are discussing
Lordship,
of
in
section 5.
respect of the stay petition, Lordship, if you're, it's my learned
Say
friend.
First, cross the hurdle of condonation. If the condonation is refused, then everything goes.
So my learned friend says he's
Oh,
not.
that's why let us dispose of the condonation
Lordship,
first.
Lordship. Lordship, page 7, Lordship, paragraphs 4 onwards is the explanation.
Paragraph 4 onwards. Now, this is an application for condonation of delay in filing the instant appeal beyond the statutory period of limitation provided there. After perusal of the explanation offered in paragraph 4 to 10 of the instant application, we are satisfied that the petitioner was prevented by a sufficient cause in not filing the instant appeal within the period of limitation. Accordingly, the delay in filing the instant appeal is hereby condoned. The application is allowed. The office is directed to formally register the appeal. What is the nature of the impugned order, sir, madam?
Lordship, in impugned order, Lordship, what happened was here the writ petitioners, my learned friends' clients, Lordship, are the employees of the National Instruments Limited, Lordship.
National Instrument
Yes, National Instrument Limited.
Limited.
And it's,
So it's a
Lordship,
Government of India undertaking?
it was a public undertaking, Lordship.
Yes.
It was a Government of India undertaking,
Yes.
Lordship. Now, pursuant to the orders of the Supreme Court, certain Government of India undertakings were earmarked for getting pay scales, Lordship, for enhanced pay scales from the fourth CPC, Lordship, and in the list of the Government of India undertakings, NIL also found its place in the list. Now, what happened was, Lordship, NIL, in the meantime, while this was going on, NIL had
Let's
entered.
do one thing, because this matter is assigned to us.
Yes,
And
Lordship.
this is assigned to a regular bench, actually,
Yes, it.
presided over by me. My brother is sitting only for a day.
Then, Lordship, could I just make one prayer? Could I just
Can you
seek
come?
leave
Can you come? Can you come on Tuesday?
any day? But could I just seek leave to file a supplementary affidavit, Lordship?
That you
Because
prepare
there-
it?
it due to-
Can you do it? Can you come by Tuesday? I'm just asking. Or
By
next
Tuesday.
next
can
Friday, tell us.
Supplementary affidavit. Lordship, preferably Tuesday week. I think we'll be able to affirm it by then.
Tuesday week appears to be a holiday, I believe.
Whatever. Whichever the day after the next
Come on
week.
the next Friday. By this time, you are getting the whole week. Do it.
Just
If you want, serve the advance
yes,
copy.
yes.
Thing is group 7, this is group 6.
Sir,
That doesn't.
this is an assigned matter. I have
Assigned
seen.
matter, that is
And
why.
this is assigned to a regular division bench presided over by me. Now, my brother is sitting only for a day. Because my regular
No,
partner
okay,
is
okay.
on leave.
Lordship,
That's
Lordship.
why we are saying that unnecessarily we should not. Let this matter be listed on next Friday
Next Friday.
under the same heading. Unta. No, no, Unta ache. Let the can one or can two? Can one of such and such be
Can one
listed
is
on
contradiction.
next Friday.
I think it is can 2.
No, can one. No?
Can two is a condonation which we have disposed of.
Can 1.
Hey, আমার এখানে ভুল হচ্ছে।
Oh, then
Can one is condonation? Can
one disposed of, can two list.
এটা কি?
Yes, call the next matter.
Lordship, just filing the affidavit, even though Mr. Dotto is appearing.
What affidavit? Affidavit of service. Likhe dao. Let the affidavit of service filed today be kept on record. His appearance is already there. Anyhow. 209.
My lord, item number 9, my lord, I beg to appear for the appellant.
There is no application pending.
My lord, difficulties of the after the appeal has been admitted, my lord, still the private respondent who is union of the leader, my lord. He is preventing my bus to enter the Navadip bus stand and pick up passengers, my lord. This obstruction is going on. My client is a senior citizen, my lord. She is a bedridden lady.
Where is Mr. Alan Felix?
My lord.
Where is he?
My lord, I am a Mr. Alan Felix.
Acha,
I am
you
the
are Alan
appellant,
Felix.
yes. Mr. Johar Dotto is
Mr.
appearing for the
Dotto
state.
and Mr. Sandeep.
They are appearing for the state, my lord.
So you just, there is no application which is pending.
My lord.
I have fixed another matter on next Friday.
Friday, my lord.
No, when I have fixed this matter, hearing matter, প্রথমে হ্যাঁ না প্রথমটা যেটা বলেছি ফার্স্ট সিটিং না ওটা that is 21 22nd 22nd is let this matter appear. There is no representation on behalf of the respondent when the matter is taken up today. Stop. The counsel for the appellant submits that despite the direction, the state is not implementing the order of the single bench and taking advantage of the pendency of the instant appeal. Stop. It appears from the record that there is no application pending in the instant application. The matter has been wrongly listed under the heading application today. Stop. In such view of the matter, let this matter be listed under the heading for orders on 22nd.
Grateful, my lord.
Yes.
My lord, I beg to appear for the appellant, my lord. My lord, I am filing the original certified copy, my lord, which was not filed, the impugned order.
210.
And my lord, I am filing a supplementary affidavit regarding the delay, my lord. Application for condemnation of delay, my lord. I had wrongly stated, my lord, in the application, my lord, that there was delay of 1 month, 18 months.
Have you served the copy? Mr. Pintu Dev Rai, Mr. Subruto Guo Biswas,
My lord,
Mr. Jointo Samanto.
yes.
Last occasion you did not appear.
Yeah, both of us were not there, my
No,
lord.
no, he was there.
He was there, my lord. Then I'll get him, my
It
lord.
is the order which is
I'll get him
recorded.
in the second half, my lord.
You just
I will
inform him.
inform him, my lord, and get
There
him.
is no representation on behalf of the respondent. The appellant seeks to file the supplementary affidavit.
My lord, he's supposed to join online, my lord. His
I
clerk
do
is
not
telling.
know. Let the supplementary affidavit filed today be kept on record. The copy of the supplementary affidavit has been served.
Yes, my lord. Everything has been served. Yes. A supplementary affidavit.
This is the supplementary
That
affidavit.
is the, my lord, certified copy of the original order, my lord, the impugned order, my lord. I got it later on, my lord, from the department, my lord. And this is the supplementary affidavit.
Oh, কি বলেছি? Seeks leave to file two supplementary affidavits. Two supplementary affidavits. One in relation to the filing of the certified copy of the impugned order, and the other in relation to bringing certain facts which are relevant in consideration of the applications filed in the instant appeal. Let the aforesaid two supplementary affidavits be taken on record. Stop. Since the respondent is not appearing, we feel that another opportunity should be given, as we find that on the last occasion the appellant was not represented, but the respondents appeared. In such view of the matter, let this matter be listed on 22nd March under the heading application. Stop. The counsel for the appellant is directed to communicate this order to the counsel of the respondents immediately.
My lord. I'm grateful, my lord. I will communicate the order, man. Much obliged. Bye.
पता चलेगा आपके साथ आज फिनिश नहीं होगा. ये वाले 211. Not today. Oh, it's for the other side. It's for the degree. It's for the degree. इसके बाद वहाँ पे that has been. Now what?
My lord, the application under section 141 of the Civil Procedure Code was rejected. That order is impugned before my lords.
Is it an appellable order or a revisable order?
Appealable order.
Appellable.
Because my lord, it was a miscase, miscellaneous appeal.
Separate list is not in a position to understand. Simply says where and insofar as a degree or an order is varied, reversed in a of the proceeding or is set aside according to the proceedings. What which pass the degree or order shall on an application of any party entitled to any benefit by this. Yes, sir. Tell us, sir, whether appeal lies. I have doubts. Look at the provision of section 144. Other side says yes, not so easy, yes. Subsection 2
Section 2.
of 144. Sir, there are two things, I tell you very frankly. What troubles me is this.
Yeah.
Had it been an original proceeding originating from an application, definitely the right of appeal is reserved to some extent. It is really, I would not say supplemental proceedings, it's a supplementary proceeding. It is not provided under Order 43, if I correctly
Yes,
understood, not provided
not
under
there.
Order 43. If it is not, then in that event, whether an appeal would lie, whether it is an order under section 104.
Come under 104. Lord, it is 104, 104 subsection 2. 104 subsection 2.
What it
Your
says?
lordship, in that, in case it is an in appeal, no second appeal. It is not arising out on appeal. It is arising out.
So I was just thinking, sir, there are two modes where one can understand from an order. Either it should come under Order 43, Rule 1,
Or under section 100.
or under section 104.
Yes.
It does not come under Order 43.
No.
Then I said whether it comes under 104, it also does not appear that it comes under 104. Then if it does not, then whether this is an appellable order, I am asking. Your other side said yes, 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 yes. Facial expression was such, nothing without application of mind.
My understanding is, Milord, 144 is restoration of possession. It is in the nature of mandatory injunction. If it is that,
No,
Milord,
no, it is not. It is a duty of the court to restore the possession of a person whose possession was taken on the strength of a decree passed by him, and that decree is subsequently set aside. So that's why the language of 144 is, I do not know why the miscase is registered. If you look at the language, it says on an application before the court. So once the suit is restored, application should have been, my view is, should have been there inside that, in the set. In the same suit. Why it should be registered as, I do not know CRO. I have to see the civil rules and orders. Why separate?
Lord, earlier occasion it was rejected that it has not been filed as a miscellaneous case. Accordingly, it was rejected with revision. In revision, Lord, it was set aside, and the Honorable Justice Banerjee, Sanjeev Banerjee, as his lordship then was directed the court below, don't be technical. You register it as a miss case and thereafter decide it.
Suppose registered as a miss case. Every miss case does not mean that appeal is the remedy. Can you?
Lord, I have not thought about it.
If it is several miss cases are filed for different reasons, does it mean an appeal? Now, why this time he has rejected? Let us see, not go by a technicalities. Let us see what is the ground for rejection.
Lord, rejection ground is, Lord, what happened? It is a suit of 1993 for specific performance. And Lord, the defendant number 1 who entered into an agreement for sale, he was missing. And Lord, without service of summons, the suit was decreed in spite of direction, specific direction by the learned trial court that you serve summons in the substituted service. That order was not carried out by, instead of those they are Hindi speaking, in Bengali newspapers something was published and court decreed the suit ex parte.
Whatever. Then the
Then Lord, during
one came.
pendency of the suit, as Lord, the person was missing, his wife and 2 minor daughters, they sold out the property to a third party. And Lord, but they are not substituted. Order 22 Rule 10, Lord, it is not compulsory that should be substituted.
Who are you? Defendant number?
I'm the Lord, heirs of defendant number 1. We made an application under Order 9 Rule 13.
Set aside.
Order was set aside, and thereafter, Lord, we are not allowed to be added as parties. Though at our instance, Order 9 Rule 13 was allowed, we are not allowed to be added as a party. Our application for addition was rejected. Against that, we approached this Honorable Court, and this Honorable Court ultimately, though initially said that you will have to initiate a separate proceeding for declaration, but as it has been done in the miss case itself, Order 9 Rule 13, therefore no necessity, we are added as party. But in the meantime, the property was, execution was made and they took possession.
On the basis of that ex parte decree.
Ex parte degree.
Despite the ex parte degree having been set aside or prior to.
Prior to.
So they took
Now,
the possession through court.
Yes.
So why the court has rejected it?
Court has rejected that you have sold it.
Oh, that is why.
Yeah, yes.
That you do not have a subsisting right.
No, I have been proceeding with this suit.
Yes. That shows that you do not have a subsisting right.
Yes.
This is what?
Yes.
Show us the provisions of the Transfer of Property Act that even after selling, your obligation to remedy all the defects still retained with you.
And Lord, that apart, your lordship kindly see Order 22 Rule 10. I may not add them as party, or they may not be added as party.
You are espousing on
I am responsible, that's why I am.
because you have suffered a decree.
Yes.
Means your predecessor.
Yes.
Once the substitution is done, that means you have suffered a decree.
Yes.
Let us hear him.
Yes.
Historically taken this point, Millard, as of Millard, on the date of restitution, when they applied for restitution, you do not have any possession.
Will you give back the possession or will you not give back the possession? Tell us.
No, only one thing, Millard, if your lordship kindly, Millard, sees the provision, Millard, whether he may at all entitled to, Millard, apply. So if your lordship will kindly see where and in so far as a decree or order is varied or reversed in any appeal, revision, or any proceedings, or is set aside, modified in suit instituted for the purpose, the court which passed the decree or order shall, on application of any party has to be not party to the suit. Naturally, they may not substituted. Entitled to take benefit of restitution or otherwise. Not when they
Otherwise
apply,
means what?
Otherwise, Millard.
Because there are two concepts of the sale. One is a sale which divested the right title and interest and coupled with possession. Possession they could not give, which is their obligations. Can they not obtain possession and give it to their purchaser? That's their obligation.
Yeah, Millard, once Millard,
Sorry, we can't. They might have written, but this was not a situation. Will you restore or Mr. Ghosh, we are not going into all these,
Yes.
the paraphernalias of the procedural law.
Yes.
We will appoint a special officer here to take a position and then give it to you. Sir, you can't take advantage. You were blessed with the box of the apple. Now the court has said that that box has wrongly gone to you. You have to return it, sir. You have to return it. Absolutely wrong. Cannot.
Yes, they have given policy. They have given.
How? The position is not with them.
But that is the between him and his. They have given policy. And may I read that line? নিঃশর্ত সাপ বিক্রয় কোবালা দলিল আপনাদের নাম বরাবর লিখিয়া দিয়া এত দ্বারা স্বীকার অঙ্গীকার প্রকাশ
Something more to say.
No, Miller, this is my stand on my Miller written objection.
It is a sordid state of affair that a possession taken by a position taken by a decree holder on the strength of a decree was put in execution is taking all sorts of technical pleas to thwart the fruits of an order by which the said ex parte decree was set aside by the trial. A suit for specific performance of an agreement for sale was instituted against the predecessor of the present appellant, who was admittedly found missing. But despite the several orders passed by the court, upon the respondent hearing to effect the service in a substituted manner, no steps were taken in this regard, yet the suit was allowed to be proceeded ex parte. Immediately after coming to know of an ex parte decree, as the same was put in execution, the present appellants took out an application under Order 9 of the Court of Citizenship for setting aside the secret. A plea was taken that the appellants, being the heirs and legal representative of the defendant, cannot maintain the application for substitution, for setting aside the decree. But the court did not accept such contention and ultimately allowed the said application. Thereby, the ex parte decree passed by the court was set aside. In the interregnum, the execution case was proceeded with, and upon execution of the deeds to court, the petition was also obtained on the basis of the order passed in the execution procedure. The moment the ex parte decree was set aside, it is a statutory duty cast upon the decree holder to return the position. Having not done so, an application under section 144 of the Code of Civil Procedure was taken out for restitution of position by the present applicants. A plea was sought to be taken that since the appellants have not been pleaded as party in the said suit, they are precluded from taking out an application for restitution of position. Such plea was upheld by the trial court, but in a revisional jurisdiction, this court set aside the said order with the categorical finding that the moment they have been, the moment they emerge successful, the moment they emerge successful in a proceeding under Order 9/230 of the court, the addition is inevitable, and therefore they are required to be added in the party in the city, which in fact has been done. The developments which took place during the aforesaid proceedings was projected upfront as the appellants divested their right title and interest in respect of the properties in favor of a third party. This propelled the respondent to take a plea of demurrer that since they have lost their right title and interest in respect of the property, they cannot maintain an application under section 144 of the code. Section 144 of the Code of Procedure was incorporated with the laudable object that any benefit derived by a person through a machinery of court shall not continue to reap such benefit in the event the order which confers such benefits is set aside, varied, or modified subsequently. It further provides that an application can be made by any party entitled to any benefit by way of restitution or otherwise, can be filed before the court which passed the decree or order. What is sine qua non in this regard is that a person that a right to make an application for restitution is conferred upon any person entitled to any benefit to stop. Admittedly, the original defendant was found missing, and the substitution has been effected. The treating the said person to have suffered a civil death, and therefore the word any person entitled to benefit by way of substitute, by way of restitution or otherwise, has to be construed in such perspective. Using the expression or otherwise, the legislatures were conscious that it is not possible to think about all conceivable situations, and therefore expanded its horizon beyond the expression any benefit by way of restitution. And therefore, any restrictive meaning assigned there could offend the legislative intent or the avowed object for which such provision was incorporated in the statute. Even if the appellants have divested their right title and interest in respect of a property to a third party, yet it does not efface their other obligations incidental and attached to such sale. Admittedly, the position of the property is still with the respondent. And even if the sale is effected, indicating the position have been given, the same cannot be said to be a correct state of affair, more particularly when the respondent is uniform in his stand that the position remained with him on the basis of the strength of a decree passed in the suit, and an application is taken out by the appellant for restitution of position. We cannot comprehend the findings of the trial court that once the divestition of right title and interest is effected, it debarred the appellants from claiming any position in respect of the suit premises. Even Order 22, Rule 10 of the Code of Civil Procedure can be applied gainfully, where in spite of the divestition or devolution of interest, the obligation of the party to the proceedings does not get effaced or obliterated as he is espousing the cause for a person claiming through him to stop. The possession is a 9th principle of title. 9th, N-I-N-E-T-H, 9th principle of title. And the moment the title passes, the possession is also required to be given to the purchaser or a title or a purchaser, and therefore the obligation to hand over the possession is still upon the vendor. And for such purpose, if any proceeding is taken out, we do not feel that it would put an obstacle in seeking such reliefs there. The order impugned is thus set aside. Considering the manner of objection to hand over the position, we feel that it would be an idle exercise if the matter is reverted to the trial court for such fringe issue. We therefore appoint. Where is the property?
Sonarpur.
Any junior member of the bar who lives near Sonarpur? Having at least 2-3 years of practice. Yes, tell us. Advocate. Sonarpur is not far off. It's not within the Greater Calcutta or
Yes.
MDA.
Yes. Nearer to
Near Sonarpur. How many years of practice? 5 years. What's the good name? We have to appoint Mr. Parashur Boito, a practicing advocate of this court, as a special officer. Take possession of the property from the respondent and file the report to this court on the next step. In the event any resistance is caused to the special officer, it is open to him to approach the concerned police station, and on such approach, the officer in charge of the concerned police station will provide an adequate police assistance to the special officer. Forthwith, on the basis of the server copy of the instant order of this one, server copy of this one. Stop. It is open to the police officer or personnel to remove all obstructions, if any cause. An appropriate step shall be taken in this regard. Stop. The special officer shall put his padlock on the main entrance of the suite and shall keep the keys of the safe until further. Let this matter be listed. The initial remuneration of the special officer is fixed at 1,000 gold bar, 17,000, to be paid by the appellant, to be shared by both the appellant and the respondent.
Kindly do not, it's based.
I was thinking of imposing on you all. No, because of you, this has happened. Shares by both.
But this was through
Equal share.
well, possession was given through Milord executing court.
Okay, then shared by the appellant. Since we have passed the final order, allowing the appeal, and kept this for the limited purpose of same, we think that is a fit case where we should impose a cost, which is assessed at rupees 10,000 to be paid to the appellant.
Cost part, Milord.
Don't give.
I cannot be Milord.
Sir, you are the person, you know the law very well. You know the law very well. Sorry, we will not.
Kindly, Milord. Cost part, Milord, kindly. Not,
Either share equally or 10,000.
Milord. You get possession, Milord.
No, sir. No, sir. You get position. No difficulty.
Not difficult. Cost part, Milord. Kindly, Milord.
Get a degree.
Cost part. Milord, I'll get the property, Milord. Kindly.
We are firm on this. Either of two situations. You just say.
Not,
Either by way of cost or you share.
Kindly, Milord, do not do that, Milord.
Let us start with the list of 21st March. The date to be mentioned. করে দাও শোনো the কষ্টের জায়গায় করে দাও shared equally কম পয়সা
I am appearing, my lord. This is the wife.
For the husband responsible.
I am appearing for the wife appellant, my lord. Dependent, my lord.
what is the application
Application for maintenance, my lord.
My lord, I am for the appeal.
What is the defect, sir?
My lord, the defect is the decree of the first appellate court was not there at the time of filing, and I have the report as on the date of filing that it was no decree was drawn up as on that date. And the second, my lord, the issue is that I have the learned advocate on record filed a Section 5 application, though not required. Actually, within 90 days, the first
Not file the certified copy of the decree of the lower appellate court.
I have filed the trial court's decree has been filed, not the first appellate court.
That is what I did.
Yes, actually, I have the report of the learned court below that the decree was not drawn up as on that date, on the date of filing, my lord.
Where is the decree?
My lord, decree, I don't,
Court,
it's a,
court. In the report.
he
of
will
the
judge
staff-
Navadip.
The report of the staff reporter put on the reverse of the first page of the memorandum of each. Very indicates that in absence of a certified copy of the decree passed by the first appellate court, it is not possible to give a complete report. The counsel for the appellate submits that he has taken information from the concerned court that the decree has not been drawn up as on this date.
Yes.
And therefore, the application for issuance of the certified copy of the decree is still pending. You see, now we have the opposite facts is alarming and shocking to us. The judgment which was delivered as far back as on 22nd September 2023 by the first appellate court is still begging a decree to be drawn up thereupon. We therefore direct the district judge, Nodia, to seek an explanation from the concerned officer of this civil judge, junior division, Navadip Nodia.
It would be senior, additional district and.
Oh, sorry. Yes, civil judge, junior division, Navadip Nodia.
No, decree was not drawn up by the
The first appellate court.
first appellate court, my lord.
From the additional district judge, Navadip Nodia. As to why the decree has not been drawn up, despite the judgment is delivered on 22nd September 2023 in title appeal number 4 of 2019. Such report shall reach to this court on or before 22nd March 2020. The Registrar General of this court is directed to communicate this order to the London District Judge Nodia immediately.
নামটা দিয়েছি।
আজকের সময় আমাদের দুজনকে
My lord, I am for the appellant petitioner. Can one of 20,
Lord, I am taking the plenary objection regarding the maintainability of this appeal.
This case is dismissed. Required to be dismissed. What is the meaning of the word? Order 9/13 dismissed.
Dismissed.
What is the value of the
Matrimonial proceedings, my lord.
in my judgment?
my lord?
In my judgment, I have taken a dissenting view of the single bench. I have taken a
I am for the respondent number 3.
Or I am for the appellant applicant lordship. I am at fault, my lord. Or I have misplaced my brief lordship. Kindly gives me some. Yes, my lord.
Last time also he paid
Lordship,
for it.
kindly gives me 7 days time. If I don't get it, I will get a copy from my.
That you will get it.
But I will.
You will get it.
But I will.
Again, you are coming. No, this is not expected.
Lordship, kindly grants me 7 days. These weekends time, lordship. I will.
He is enjoying.
This
Then,
application
you
for
are not-
injunction, we filed our opposition. Initially,
You are already benefited by a trial court order.
difficulty on
Not today.
Grateful to your lordship.
Yes. First time.
Your Lordship, I'm for the petition, Your Lordship. The advocate on record has sustained some injuries due to accident, Your Lordship. So I'm praying. So, Your Lordship, he has sustained some injuries due to an accident, car accident. So, Your Lordship, today. Much obliged.
Right, I'm for the applicant. You have received the copy or can we say? The friend has served us the copy.
Application.
But this application. Of party added or three respondents died prior to filing of the application.
One rule 10(2).
No, we just go through that.
Not go through. He will be making an argument. Have you brought the judgment of the Supreme Court?
That is not in my.
2000, volume 8 or 9 SC. Have you not brought?
Yes, my lord.
Always the court has to tell you that what are the judgments which are there.
Usually these matters hard thrice.
You need to prepare yourself, sir. Come with those line of judgments.
Yes, your lordship. That's my. Thrice the matter of hard by your lordship. That's my defect, your lordship. Words. Foundation of delay, all those things. Setting as an amendment. Because the diet prior to appeal.
Not question. Not a question of substitution. Because the party died prior to this, prior to the institution.
For 4 years prior.
So, whatever. So now, the apex court in that judgment has said that it is not a case of a substitution, but it's an addition.
Yes.
You can ask for an addition.
Yes, Lord. That is why application made.
If the abatement cannot occur as a whole, then what? Unnecessarily technical case. Merit. Decide the case on merit, throw them out, no difficulty. Not a technical.
I leave it to you.
What are those applications?
Well, addition of several departments.
What is the number of your applications, sir?
3 applications.
Oh.
Oh, can number 10, can number 11 and can number 12. 10, 11 and 12. Earlier application was wrongly done by the substitution application.
Is the can 3.
Yes, my lord. Can 3 is I want to withdraw can 3.
And what about can 4?
Can 4, can 5, can 6.
You want to withdraw?
Yes, my lord. All,
Can 6 also?
also.
Can 7 is section 5, I find.
Yes, and supplement.
Yes. Can 7 also you want to withdraw?
Yes,
Can 8 is also section 5.
yes, my lord.
So 3 respondents, 3 sets 5.
Can 9 is also section 5.
Yes, my lord.
Then can 10, 11 and
Can
12
10,
are
11?
The application for addition.
Yes,
One application was sufficient enough.
but separately I have done it.
For some good reason, then I understand.
Yes, my lord. My lord, actually, this is a lack of knowledge, your lordship, that. Yes, my lord.
Eight. For the appellate witness. I did not. This should be 7. That should be okay. These are the applications taken up. The ASM respondent number. Three.
Deceased respondents have been partly what do you think about it? They're not brought to some since the point has been taken from the last of his we invited the attention of the parties or sorry, it was not 161, 168. Was it volume 9, SCC page 168. May I have a glance to the book? Page 168. Required to be invoked. But each has gone to a judgment. Spoke in case of state of Kerala versus Sridevi and others. He quoted also for 9 page 168, where in an application for substitution was sought to be made. And the court held that since the death was prior to the institution of a proceeding, the proper move would be an addition under order 110 of the court in the following paragraph rule 10 of the court. The fourth paragraph 5. Specifically of the matter, since the factum of the death of the aforesaid respondents were not within, and it was brought to the person, we feel that dismissing the appeal on such scope will only encourage the subsequent appeal to be filed, allowing the application for contact, including the heirs and the legal representatives of those deceased respondents. We therefore dispose of the opposite appeals
apposite applications directing the heirs and legal representatives of the respective deceased as shown in paragraph 1 of those applications to be added as a party respondent in the instrument. The office is directed to make necessary amendments in the memorandum. Next.
Grapefruits.
বিরোধ দিয়ে দেওয়ার সঙ্গে সঙ্গে পড়ে থাকবে কেন?
Well, I am for the application. This is the application for restoration, but I have served the copy blood. On 30th August 2023, the matter was came up before your lordships along with well, application for restoration.
Which one?
Well, the can one.
Stage?
My lord?
Order 41 stage?
Yes, yes. On the order 41 stage.
It was at the order 41 stage?
Yes, yes.
Despite service, there is no representation on behalf of the appellant, respondents. Where is the affidavit of service?
My lord,
Where is
affidavit of service has been provided.
Board of intimation served, unclaimed. Service.
Well, according to track report, all are daily.
No, sender. To the sender. Ye has returned unclaimed. Intimation has been given. Board of unclaimed. Yes, despite service, there is no appearance on behalf of the respondents. This is an application for restoration of the instant appeal, which was dismissed for default on 30th August 2023. So after perusing the amendments made in paragraph 6 of the instant application, wherein it is stated that the advocate and record of the appellant overlooked the listing of the said matter on the said date and therefore could not attend the court, appears to be sufficient explanation for non-appearance on the said date. Accordingly, the application is allowed. The appeal is restored to its original file and number. Let the appeal be listed under the heading Order 41, Rule 11 of the Court on next Wednesday. Date be
it will appear on
next Wednesday, sir.
Instead of Wednesday or Thursday, any other day. But I have personal difficulties. I will not come, my lord.
Monday kore dao.
Yes, it's very good. Monday. I'm grateful.
Let's call the next.
Lord, may I just inform your lordships, my lord, we lost Mr. Kapoor, my lord, senior Mr. Kapoor, today in the morning.
Oh.
Yes, so, Lord, since our members will be going, my lord has requested not to pass any adverse order in their absence.
Your lordship, I am for the petition amendment.
What is this application?
My lord,
this application is for stay, my lord. Application for stay. There was Can 1 application which your lordships have already allowed. That was for the condemnation of delay, my lord.
What is the nature of the decree?
My lord, it is a partition suit. It was a preliminary decree has been passed, my lord. My lord, may I just
Where is a
service, my lord? I have already submitted, my lord. The Can 1 application at the time of hearing of the Can 1 application, I have already
This is an application for stay of all further proceedings in okay. What are you talking about? Sorry, this is an application seeking a stay of the operation of the impugned preliminary decree pending the instant appeal. A suit for partition is decreed in preliminary form, declaring the right title and interests, declaring the shares of the parties to the said proceedings, which is assailed in the instant appeal. We do not find any. We do not now. In the event the final decree is passed, it would not only cause immense injury to the present appellant, but may virtually render the instant appeal infructuous, and therefore we do not think, and therefore we feel that pending the instant appeal, an interim order is required to be passed. The application is thus disposed of with the following direction. 1. Pending the instant appeal, the trial court shall proceed with the partition commission work and shall also decide any objections, if any, raised by either of the parties to the proceedings. 2. Till the disposal of the instant appeal, the trial court shall not pass any final decree in the said suit. 3. The trial court is the advocate and record of the appellant. The appellant is directed to put in the special messenger costs for bringing the lower court record, and such costs shall be put in within a week from date. Next. While sending the lower court record, the trial court will make a skeleton record for the purpose of the partition commission work, so that the same is not hampered for the reason that the lower court record has been sent to this court. Next. After the arrival of the lower court record, the trial court, the office, the department shall scrutinize the same. Shall examine the same, and if found complete, shall issue a notice under Rule 12 of Chapter 9 of the Appellate Side Rules upon the advocate and record of the appellant. Next. The appellant is directed to prepare 8 copies of informer paper book, cyclostyle, Xerox, printed, typed, charge, within 4 weeks from the date of the service of notice of arrival record. All formalities, including the preparation, including all formalities, including the filing of the appellant declaration for the purpose of preparation of the paper book are dispensed with. The appellant is also, next paragraph, the appellant is also directed to put in the requisites for effecting the service of notice of appeal upon the respondents within a week from date. So, on deposit of the requisites, on filing of the requisites, the department shall immediately take steps for service of notice of appeal upon the respondents and shall submit the report in the file in this regard. After the filing of the paper book, liberty is granted to the parties to pray for early listing of the instant appeal.
Deeply obliged. Okay.
I am for the appellant. Well, this is appeal is challenging the granting of order of probate, my lord. But on the last occasion, my lord, Lordship was pleased to direct my lord for exchanging affidavit. My lord, I am filing affidavit in reply, my lord.
Appeal by a stranger, there is no application for leave to prefer appeal. He is not the caveator. He is the brother of the caveator.
No, my lord, my defense was struck out, my lord.
So you are not a party there.
Section 5 has not been allowed as yet.
No.
68 days delay.
On delay, I have nothing to say, but maintainability, Lordship will kindly come.
So let us dispose of the application for condonation first. Which one is the application for condonation?
Well, this is my
Can one.
actually, my lord, delay was, my lord, one of the reasons, my lord, appellant was under impression, my lord, proper remedy would be, my lord, before the learned trial court for revocation of probate, my lord.
This is an application for condonation of delay in filing the instant appeal beyond the statutory period of limitation provided therefore. After perusal of the explanation offered in paragraph 4, 5, and 6 of the instant application, we are satisfied that the petitioner was prevented by a sufficient cause in not preferring the appeal within the period of limitation. So, the delay in filing the instant appeal is hereby condoned. The application is disposed of. Let Can 2 of 2022 be listed in the next week.
No, my lord. My lord, appellant, my lord, is the, my lord, brother of the contestant.
Yes, call the next.
Your Lordship, learned advocate for the appellant is on his legs on court number 24. I am praying for not today, Your Lordship.
Where is Mr. Raghunath Das?
Yes, Your Lordship. Advocate for the advocate on record, Your Lordship. He's on his legs at courtroom number 24, Your Lordship.
So,
I'm praying for a short Passover or the not
Passover.
grateful, Your Lordship.
Lord, 24, Lord, I am for the petitioner, appellant petitioner, Lord, with an application for restoration. The order 41 matter was dismissed for default. Lord,
Have you served?
though before.
Have you served
No, my Lord.
service? 2 weeks.
Lord, earlier date, my Lord.
Weeks. We have
One-
given
1 week.
1 week. We will not give an adjournment if you say that the service is not complete.
Right, 2 weeks. Because of my Lord execution that.
Whatever. Next.
225 million. I'm appearing for the petitioner, my lord. Sir, this is an application for injunction, my lord. I have served the copy of the other side, my lord.
For
Injunction, my lord. Sir, my suit for recovery of money was dismissed.
you were supposed to supply the translated English
Sir,
copies
translated
of the
copies. This is the translated copy. To undertaking by the deceased.
What is this application?
My lord, the application, my lord, this is the only property which the
I am asking what is this application?
application for injunction.
Injunction. Whether you were enjoying injunction during the
My lord,
pendency of the suit.
in the trial court, my lord, what has happened, my lord, injunction was refused. Thereafter, we moved that injunction appeal application before this honorable court, and before this honorable court granted injunction application at interim basis. Thereafter, ad interim injunction was made absolute till the disposal of the suit before the trial court. My lord, that is the matter.
One sentence would have been sufficient that yes, I
Yes,
was enjoying
yes.
an interim order during the pendency of
During the
one sentence. So many words were not required to be told.
Great. Page 100, my lord. That is the order passed by this honorable. আপনাদের absolute করলো কোথায় অর্ডারটা?
What injunction?
absolute করলো অর্ডারটা কোথায়? কোথায়
Yes, where is the where is the order of injunction operating in the
My lord, my lord, may I read the order of the trial court, my lord? Though the initially this court has turned down
I just wanted where is the main order of injunction?
main order of injunction, my lord.
Order of the injunction I want to look at.
My lord, main order of injunction, my lord.
What was the nature of the injunction which was granted by this court, by the trial court, whatever? I just wanted to know.
Till disposal of the instant suit.
What injunction?
Injunction, my lord, not to alienate and or encumber it and or creating any third party interest, and the order was made effective by this
In
court till
respect of
disposal
B schedule property.
Yes, my lord, in respect of the B schedule property.
Show me that. Where is that? Have you annexed that order?
Memo of appeal. My lord, in the memo of appeal, my lord, that order, interim order is that reflected, my lord. And I have interim order copy টা আছে? Copy কোথায়? Page 118, my lord, of my injunction application, B schedule property. Page 118 of my stay application. That is the amended plaint, my lord. The plaint was amended thereafter, my lord. That is B schedule property. All that two-storied building lying and situated at Matla 1, Matla FL Offshop near Canning, Puratan Harishobha, Canning, such and such, Canning, PS Canning. This is the property, my lord, which I got the order of injunction. অর্ডার অফ ইনজাংশনের কপিটা কোথায়?
তুই
যেটা
page
অ্যাবসলিউট
two,
করলো না, যেটা
two order-
অ্যাবসলিউট করলো।
ওটা 100 এ। ওটা এখানে নেই, ওইটা এখানে অ্যাকশন নেই, যেটা আপলোড করলো সেটা অ্যাকশন এখানে নেই। This code.
তো ব্ল্যাঙ্ক ওটা তো রাখা উচিত ছিল, ওই অর্ডারটা তো রাখা উচিত। স্যার মে আই কাম ব্যাক উইথ দি ইনজাংশন অর্ডার মিলার?
Since we are live streamed, we don't want to make any observations.
Sir, I
But the difficulty,
I
only
apologize.
one observation I can make, that you have not read the brief.
What has happened, that injunction order, I guess, which
Sir, come to page 101 of your petition, you have annexed that order, which is made absolute. Bottom, last paragraph.
last paragraph.
Under the circumstances.
Under such circumstances, there shall be an order of injunction restraining the defendants from.
That's why I say you have not read your brief. I do not want to say anything on that. You said that this order was made absolute. Despite service, there is no representation on behalf of the respondents. Let the affidavit satisfied today be shown. Now, just you heard that ex parte should be disposed of.
The poster remark refused.
Somebody must be of that library who is engaged in the matter. We don't know.
Sir, what has happened, the poster? I accept it.
Not today, Kurat. Take back your affidavit, sir. My brother reminded me
That is the translated copy, Miller.
Oh. No, affidavit of service, take back.
Service to the answer. Service already submitted.
Not today only. Take it back. No, take it back. Yeah, give it.
8 o'clock now.
Let's call the next.
But this affidavit of service for a 30th January, you're also
Other
direct.
side is here. Today is an exceptional just
I have heard
mention.
of that.
So we do not want.
I know it. Yes.
Call the next.
Lordship, I'm on behalf of the appellants. There was a mistake in the cost title. I'm praying for liberty to make the necessary changes or corrections.
See. You have not put in the title suit number?
Yes, Your Lordship.
Why? Order was passed on 17th of November 2023 by the Lojima bench.
Yes, Your
Yet
Lordship.
you have not done it.
Yes, Your Lordship. I'm praying for liberty so that I
What
can.
liberty? You were directed to remove on 17th of November. You did not remove it. You did not care. You did not find time to go and remove the defect.
Your Lordship, I'm being assisted by Srijip Chakraborty. So
you are assisted by Srijip Chakraborty.
I am assisting Srijip Chakraborty. Your Lordship, I was not aware of the changes, corrections which were required to.
Why? Who is the advocate and record?
I'm the advocate.
So, is it your duty or is the duty of your senior?
Your Lordship, I pray
So-
for. I'm apologize. I can make the necessary changes if Your Lordship permits.
Oh, complacent.
I apologize, Your Lordship.
Leave is granted to the advocate and record of the appellant to remove the defects as pointed out by the stamp reporter here and now.
Yes, Your Lordship.
Lord, I'm appearing for the respondents number 1 to 5.
Thank you for your appearance. Yes.
My lord, I'm in this case, I'm on behalf of petitioner, sir, praying for a Passover, sir.
My lord, I am for the section.
Where's the other side?
My lord, there was a direction to serve, my lord, although the service has returned. Now,
Today is an exceptional day. There was a request made at the bar
my lord.
that if the other side is not here,
But my lord, may I make one submission, my lord? My lord, our instruction is that the respondent, my lord, is not here itself. And she has somehow gone to Bihar and she is now residing there. We don't know the address. So my lord, may be pleased to direct a paper publication.
come on the next day if she is interested. Come, not today only.
My lord, I'm grateful.
My lord, 129, my lord, I am for the petitioner. My lord, I am praying for a short Passover, my lord.
Next.
My lord, in this matter, my lord, Srimati Mousumi Bishas is appearing for the respondent. She has not come today due to her son's illness. So I am praying for not today, my lord.
Not today.
Grateful to the lordship.
Next.
231.
फिर दो कोनो लाभ नहीं कंटिन्यू ठीक है जाओ
I am appearing on behalf of the state.
other side other side
I'm for, look, I have noticed has lost caveat.
other side is here.
No, my lord.
Because today is an exceptional day, that's why I am asking.
Well, kindly fix on next, well, at the,
Yes,
give some
next.
preference to the.
Next.
My lord, in this matter, I am for the petitioner. As per your lordship direction, I have served the copy of the condonation of delay application, but in the meantime, the sole respondent died. So I have preferred a substitution application. My lord, kindly direct us
Give
to
the
serve
number.
the petition.
Give the number.
No, actually, the CAN number 3 of 2024 with the.
When you find it, give it.
It is tagged with the main file, your lordship. It is appearing.
3 is here. Then move CAN 3.
No, my lord, my clerk is bringing the.
It's a matrimonial suit or what?
No, my lord, it is against the
Because I find
order
the
of probate passed by the
surname is one and the same. And one is a male, another is a
It is
female. That's why
it's an order of probate passed by the district delegate Alipur, your lordship.
Let us see.
My lord, in this application, your lordship, substitution application 238. Tarotin.
This is an application for substitution of the heirs and legal representative of the deceased respondent who died on 25/2/2024. The name of the heirs and legal representatives have been disclosed in paragraph 2 of the instant application. who are major and sui juris and a person of sound mind. Since the application is filed within the period of limitation provided therefore, and the right to sue survives upon the heirs and the legal representatives, we do not find any impediment in allowing the said application. Accordingly, the application being Can 3 of 2024 is hereby allowed. The names of the heirs and legal representative of the deceased respondent as disclosed in paragraph 2 of the instant application. The names now, the heirs and legal representatives as disclosed, be substituted in place and state of a deceased respondent. Office is directed to make a necessary amendment in the memorandum of appeal. So, the appellant is directed to serve the copy of the pending applications upon the substituted respondents by speed post and shall file the affidavit service on the returnable date. The pending applications being Can 1 and Can 2 of 2023 be listed after 2 weeks. Be listed now, shall be listed. Next.
Not for the petitioner, not appellant, this appeal is arising out of a matrimonial proceeding. Not I'm the wife. So that there's a
Well, 43 exceptional day.
48, my lord, I am for the appellant. This is the first time. কিন্তু দেব কি করে অর্ডার না থাকলে দেব কি করে? আরে বাবা আমাকে ডাইরেকশন না দিলে পাঠাবো কি করে? My lord, my lord, my lord, with regard to item number 248, it is a partition suit ad interim injunction.
Whenever the
It is the
judges,
first time.
whenever the judges are consulting,
My lord, I am praying for
some
apology.
reasons,
My lord, I am praying for
at least that's a decorum which we have inculcated since 150 years. Never disrupt.
My lord,
There
I am
may be
praying for
something which
apology.
is going.
I am praying for apology.
What 248? What
248, my lord, it is injunction application has been filed in partition suit. Preliminary injunction application has been rejected. Against that, I came before your lordship.
preliminary injunction application rejected? I have not
Preliminary
heard of
order, preliminary order.
preliminary order in the injunction. I do not heard of it. I have not heard. This expression is unknown to me. Ad interim order, if you,
Ad interim.
I can understand.
interim.
Preliminary order, I do not know.
Ad interim. Ad interim is rejected. Against that, I came before your lordship. And unless there be an order, direction to sub
Has
the
it been admitted or not admitted? Then it is wrongly appearing under the heading application. The matter is wrongly appearing under the heading application. Let this matter be listed under the heading order 41 rule 11 of the court. Yes.
My lord,
In the next week.
date may be fixed, my lord.
Next week, yes. Next.
Lordship, in item number 261, on behalf of the appellant, Lordship, I have been instructed by the client that
On behalf of the appellant.
on behalf of the appellant, that the original plaintiff was known to your lordship.
Oh. Sorry. Since one of us, give my name, is not inclined to take up this matter on his personal ground, let the matter be released from this day.
I'm grateful.
And be placed before the Honorable Chief Justice for assignment. Yes, thank you. We appreciate the good justice. Yes. Continue करो. Stop kota.
3, 4, 5, 6, 7, 8, 9, 10, 2, 5, 6, 7, 5, 5, 6, 7, 8, 9,
"99, my lord, our matter, my lord. Your lordship possibly remembered, my lord. For urgency, I have moved before your lordship that it is such a matter.
Other side,
My Section 5 Limitation Act, my lord, they are
have
not
you
taken.
served?
Yes, my lord, we have served, my lord.
Where is the service?
Service, my lord, that if it be so, my lord, I have come, my lord, with the hope.
Have you served?
Yes, we have served.
Where is
So,
the
Lord, I'm giving,
service?
my lord, here at the juncture, I am giving in the course of the day, my lord. My lord,
We'll have to
my lord,
give-
within 5 minutes, my lord, one thing may be done, my lord, one thing may be done. Let it be fixed on, my lord, that on the next Friday, my lord, I do not like to disturb it because we have served the other side and I have seen in my own eyes because it is there, my lord, that I am
But
giving
unless,
it.
sir,
As old
sir,
man.
order, I understand, sir, or unless the order, the record is corrected, there is something on record, we cannot proceed. So in that event, you'll have to file a affidavit of service.
Yes,
File it.
it is there. And my lord, what I am saying, my lord, that's
Next Friday.
no, my lord, one thing, my lord, if the matter will be taken up seriously, my lord, then my means final decree will be, my lord. Then I am saying, my lord,
Don't underestimate the pace of the bench. Don't worry.
No, but my lord,
We will be taking applications on 2 days in
Yeah.
a week. Don't worry.
but my lord, we are, my lord, waiting in this way. That means the Sialda Court Senior Division, my lord, that he is trying in this way that and he has already, my lord,
You come ready, just say, we will take up the matter. Don't worry about it.
But my lord, it will be better, my lord, that today I will say, but my lord, it has been reported to me that the Mr. S.K. Kapoor, my lord, that he has gone to the another world. My lord, just now. But my lord, I do not like to disturb your lordship, but because even the honorable chief justice has ordered. But my lord, this is another time. But my lord, what I am submitting, my lord.
Next Friday it will be there. Why you are
But my lord, next Friday, my lord, again, my lord, next Friday, specially fixed, my lord, next Friday. Next Friday, my lord. Next Friday, this is the upgrade, my lord, because that
first category of application is there.
Yeah, my lord, first category of application, my lord, let it be.
Next.
I'm grateful, man. I'm grateful. I'm grateful to your lords.
Next. 10 minutes if possible. Yes. Yes, move.
My lord, it was filed by, I'm for the wife. My lord, the suit was filed by the wife under section 13(1) of
59. My lord, I am not the respondent. 59.
Appellant is not here. Three 365 review तो হবে না এই বেঞ্চে review or contempt হবে না এই বেঞ্চে yes any other matters where both sides are here have you filed the calculation
My lord, I am ready with my tabulation sheet, but may I file it by tabulation sheet and serve it upon the
consult sit together find out you have those documents show us the documents that you have paid she will corroborate it whatever is left you just tell me thereafter we'll take up the
She has already accepted what the tabular sheet we have given to her, that she has got all the payments except 10,000 rupees here and there. She is not getting that. So,
you take instruction that 10,000
yes. That I will take instruction, and in between I have asked my learned friend to give me a tabular sheet.
come on next day we'll definitely take up we will be taking up applications on 2 days in a week don't worry
No issues, my lord. My lord, if it's on Monday, my lord, kindly take it up on Tuesday. I am not.
we have not decided when application will be taken up Monday not likely to be taken up
I'm ready.
May I file it by a tabulation sheet and I am served it upon the
Serve,
Yes, my lord.
both of you sit together solve otherwise it will not
My lord, may I file my opposition, reply, my lord?
This matter is
That matter, my lord.
so urgent.
Yes, my lord, interim order is expiring today. That is why, my lord. My lord may remember in last week, my lord also have.
My lord, I am appearing on both the state respondent.
I see the photograph. I am opposition. How can I a person living with this your lordship has said this everything. But
Today is the day. Yes, this matter has come up by way of an
your
assignment.
Lord, kindly photograph.
There is already an order. You have suffered for a few days. Matter has come up by way of an assignment before us.
My lord, I am appearing on
citing
behalf
an-
of the state.
It appears the interim order was passed as far back as on 1st of March 2024 and is operative till date. Considering the counsels for the respondents vehemently opposes the prayer for extension of the interim order. Stop. We have seen the assignment having made to us by the Honorable Chief Justice. Stop. Considering the fact that the interim order was operative, let the same be extended for a period of 1 week from date or until further order, whichever is earlier. Let the matter be listed on Tuesday.
I am appearing, my lord. My appearance be recorded.
Yes, please give your memo of appearance on
Yes,
the chat.
my junior is there, my lord, already given.
My lord, matter is assigned to my lord for permanent, not for day
Only for today.
Today. Then, my lord, it will go to Chief Justice Court.
We have said on Tuesday.
Wednesday, my lord, because
not Tuesday.
Tuesday. Because, my lord, on only on Tuesday and Friday, my lord, Group 9 matters. Monday, Wednesday, and Friday, Group 9 matters are being taken up by the Honorable Chief Justice.
Then Wednesday, go.
That is why, my lord, Wednesday. And my lord, I have filed my written reply to their objection. Kindly record.
Let the reply filed today, Prathame, by the appellant be taken on record. Yes. Call the next.
Grateful to my lord.
Immediately type করে পাঠাও এক্ষুনি পাঠাও 5 মিনিটে কি আছে কল করো কি আছে what is this assignment order টা দাও
It has been already in the website, it has been published.
No, this is the original side matter. I do not know what is this matter.
Oh, original side.
Yes. Let's call the list. The matter is assigned to this bench. The matter is assigned to this bench today for the reasons disclosed in the lay note put before the placed before the Honorable Chief Justice. There is no appearance on behalf of the parties. Let this matter be listed on next Wednesday. এক্ষুনি দাও 5 মিনিটে